just a few weeks back, the Twin Tower demolition in Noida made headlines, and there was a lot of talk around it. However, what we may have missed is the judge and the judgment that actually gave the order for the demolition of the illegal structure. The demolition was ordered by a Supreme Court bench headed by Justice DY Chandrachud, and Justice Chandrachud was recently appointed as the Chief Justice, the 50th Chief Justice of India. Now, what makes Justice Chandrachud important and infamous also is his dissenting judgments, and we may look at the judgments of the decriminalization of 377 or the Ayodhya judgment or the Sabrimala case. We can actually turn the pages of our history, and in the last decade Justice Chandrachud has been part of every important constitutional judgment, almost every important constitutional judgment that India has seen. Therefore, it becomes very important that we talk about this justice who has just become the Chief Justice of our country. My name is Ishan Fauzdar, and I'm going to do entirely this in this video. You are watching The Upfront. This may be the most boring part of the video, but it is the most important. It is arguably important because we need to know the person and the personality and his early life. Justice Dhananjay Yashwant Chandrachud is the son of late Justice Yashwant Vishnu Chandrachud, Justice Y.V. Chandrachud and Prabha. If you do not know Justice Y.V. Chandrachud, he also served as the Chief Justice of India from 1978 to 1985. And he is the longest serving Chief Justice that India has ever seen till date. Justice Y.V. Chandrachud, Justice DY Chandrachud is also the first son of a Chief Justice who has become the Chief Justice of India. First father-son duo to do it, which is also pretty awesome, pretty cool. If we look at the educational qualifications of Justice Chandrachud, DY Chandrachud, he did his honors in mathematics and economics and mathematics from St. Stephen's, after which he did his LLB from Delhi University. Further on, he went to Harvard to do his LLM by acquiring the prestigious INLAC scholarship, and he also stayed in Harvard to do his doctorate in judicial studies JDS, which he also did from Harvard. After that, Justice Chandrachud was an advocate in numerous high courts and the Supreme Court, following which he was made the judge of the Bombay High Court. He served as the Chief Justice of the Allahabad High Court and the Additional Solicitor General of India. Only the senior most judge of the Supreme Court becomes the Chief Justice of our country. And if we look at the tenure and the career and the record of Justice Chandrachud, we understand what seniority actually means. Now comes the interesting part of this video, and we will now look at the important and the notable judgments that Justice Chandrachud has been a part of, in which he has either concurred or dissented with the majority opinion. The first case is obviously the case of Justice Puttaswamy versus the Union of India, which is generally called as the Aadhaar case or the right to privacy case. Yes, this is the landmark judgment that recognized right to privacy as a fundamental right under Article 21 of the Indian Citizens. And if we go a little deeper, this is also the case which was filed against the Aadhaar bill or the Aadhaar Act that was brought forth by the then UPA government. Initially, a 5-judge bench was constituted to review the petition, calling the passage of the Aadhaar bill as a money bill unconstitutional. Now, the story is a bit long, I would not be able to go into that, but just know that at that time the UPA government had termed this Aadhaar bill as a money bill and passed it through the parliament, and it is easier to pass the money bill through the parliament because the Rajya Sabha cannot withhold it. This petition was calling this terming of the Aadhaar bill as a money bill unconstitutional, and this is what the Supreme Court bench was to judge. Justice Chandrachud was the only judge in this bench who dissented against the majority opinion or majority judgment of the Supreme Court, which said that the passage of the bill as a money bill was constitutional. Justice Chandrachud held that the passage of that this bill should not be termed as a money bill and should not be passed as a money bill, and he was the only judge to do so in the bench, in the 5-judge bench. It was a 4:1 decision. Later, a 9-judge bench was constituted in the Supreme Court, and this Justice Chandrachud was a part of this bench as well, and this bench unanimously agreed that some parts of the Aadhaar Act some provisions of the Aadhaar Act were unconstitutional, as they contravened the right to privacy under Article 21, which is the right to life of the citizens of India. Justice Chandrachud wrote the judgment on the behalf of 4 judges, and the other 5 also wrote concurring judgments. It is also interesting to note that in this very judgment, Justice Chandrachud set aside the judgment of his father, Justice Y.V. Chandrachud, in the infamous ADM Jabalpur versus the Union of India. In this infamous case, the Supreme Court had held that the right to life of the citizens under Article 21 can be suspended in the times of emergency. Justice Chandrachud termed this judgment as seriously flawed and reiterated that life and personal liberty are inalienable to human existence. The second notable case is the Navtej Johar versus the Union of India, in which the Supreme Court decriminalized Section 377 of the Indian Penal Code and legalized same-sex relationships in India. Justice Chandrachud wrote a concurring opinion in this judgment, holding that 377 was an anachronistic colonial law which violated right to equality, freedom of expression, life and privacy. The third important judgment, and by far the most controversial one, is the case called the India Young Lawyers Association versus the state of Kerala, infamously known as the Sabrimala judgment. In this case, the Supreme Court and Justice Chandrachud held and judged that the exclusion of women aged between 10 to 50 years from a temple in Kerala was unconstitutional, and it prevented and it violated several constitutional values such as liberty, dignity and equality. Justice Chandrachud in his judgment also uniquely held that this practice was also against Article 17, which abolished untouchability. Apart from these, there are several other cases that Justice Chandrachud has been a part of, such as Joseph Shine versus the Union of India, in which he decriminalized adultery, and a recent case in which the Supreme Court held that the right to abortion was a right of the Indian woman, and it was a matter of personal autonomy and reproductive choice of the women of India, which goes in complete contradiction to what we are seeing in the United States now. Yeah, so India has been pretty progressive when it comes to abortion. Justice Chandrachud has also been a part of a judgment that stated that the Lieutenant Governor of Delhi is not the government of Delhi. Delhi has elected government, and many other important cases. But I would like to end this video with the infamous case of Bhima Koregaon, the Bhima Koregaon case, and how Justice Chandrachud dissented in this case. What is the Bhima Koregaon case? Well, it is a very long, that is a completely different video, but long story cut short, it is the case began as a case of caste violence in the town of Bhima Koregaon near Pune, and it quickly and very abhorrently escalated to an alleged Maoist insurgency, Maoist revolution, attempted at the assassination of our Prime Minister Narendra Modi. How this escalation happened, no one knows, but we know that huge names, big names such as Sudha Murthy, Ji Sai Baba were accused in this case. Now the police investigation in this case was dubious, very dubious and very careless, and therefore Romila Thapar and others filed a case in the Supreme Court, asking and praying that an independent investigation be launched in this case. The case went to the Supreme Court, and the 3-judge bench held the Supreme Court 3-judge bench held that no independent investigation was needed in the Bhima Koregaon case. However, Justice Chandrachud was the only judge who dissented, who was a judge in the judgment, and he dissented against the majority judgment and held that an independent investigation was needed, because he held that that the police had been careless and the police had been dubious in a lot of instances, and he pointed out certain instances, clear instances of police carelessness. For example, he argued that the police had made a case of prime minister's assassination in the public, but the same had not been argued in the court, and no such case, no such document had been filed in the court, though many letters were published in the media by the police officers. Why is that there? Hence, Justice Chandrachud held that independent investigation was needed, and Justice Chandrachud ended his judgment, and I will end. He did not end his judgment. He held in this judgment, and I will end my video by this quote of his, by this statement of his, and he said, and I quote: "Dissent is a symbol of a vibrant democracy. Voices in opposition cannot be muzzled by persecuting those who take up unpopular cases." I hope you like this video. If you did, please do like our YouTube channel, subscribe to our channel, and press the bell icon whenever you so that you receive regular updates and whenever we upload a new video. Thank you so much.